And he wasn't. I am just trying to make sure what I thought you were saying, what your understanding was, okay? He was not suggesting to you that this was a long-term media problem, right? He was just concerned about your Time magazine job applications. If you can clarify that, what you are asking? You were exploring some opportunities in 2016 and 2017, right? Eyes. And there was at least a possibility that you could take a role at Time magazine, correct? In 2016, we were looking to acquire all of Time. I wasn't looking to just take a job and leave to become president of Time. I was acquiring it. It was a matter of acquiring the company. And there would be a change of roles for you, correct? Eyes. And in connection with these conversations with Michael Cohen, you did actually have somebody review these boxes that we have been talking about, right? Eyes, and based on your review you knew that everything in there was worthless, right? That's correct. You are not suggesting that there is a trove of sensitive information about President Trump at the National Enquirer, correct? Eyes. There was nothing, it was worthless, correct? There was nothing in those boxes? And you believe they were worthless? They were worthless. You have an agreement with the district attorney's office, right? Eyes. That's an agreement that you entered into in October of 2019, correct? Yes. And what's your understanding of your obligations under that agreement? To be truthful on everything that I testify to on the questions that are given to me by any agency. And at this trial, all sides asked you a lot of questions, right? Yes, Eyes. Some harder than others? And you understand that, ultimately, they will decide whether or not they think you were truthful, right? I have been truthful to the best of my recollection. And, ultimately, they will decide whether you complied with the agreement, right? Eyes. Mr. Nothing further, Judge. The court, thank you. People, any redirect? Mr. Steinglass, redirect examination by Mr. Steinglass, yes, Judge. Good afternoon, Mr. Pecker. Good afternoon. I want to show you People's 161 in evidence. We can show it to everybody, it's in evidence. Do you remember being asked about this by Mr. Bove on cross-examination? Eyes. This is an invoice that you testified was prepared by Daniel Rothstein? Yes, that's correct. And he asked you whether you were mistaken when you testified yesterday that this document was made and kept by AMI, correct? Eyes. When AMI gets an invoice, even from a third party, do they keep it as part of their business records? Yes, they do. And is it kept by AMI to justify expenditures? Eyes. So were you mistaken about anything when you testified earlier in this trial that this document was made and kept by AMI? My question was a bad one. Do you want me to rephrase it? A business? Please. Was this document kept by AMI in the regular course of? Yes, it was. Now, you testified that prior to signing the contract with Ms. McDougal, that the General Counsel of AMI consulted election outside of election counsel, is that right? Eyes, you didn't personally speak to the outside counsel, did you? No, I did not. And did you? I believe you told us, but who was AMI's general counsel at the time? Cameron Stratcher. Now, prior to withdrawn, is Cameron Stratcher the one that reached out to outside election counsel? Yes, he did. Prior to his doing that, did you ever personally tell Cameron Stratcher about the agreement you made with Donald Trump in August of 2015 when you agreed to help Mr. Trump's campaign? No, I never did. What was your understanding of what outside counsel was asked to review? The Karen McDougal agreement. The contract? The contract. Did that contract contain provisions that we discussed at length where Ms. McDougal would appear on magazine covers and author articles as a ghostwriter? Eyes. And you testified on direct examination that the true purpose of the contract with Ms. McDougal was to acquire her life rights to her story about her romantic and sexual relationship with Mr. Trump, is that right? That's correct. And that you had included the provisions about the articles, the covers, the ghost-written articles to give AMI some plausible deniability? Yes, that's correct. Can we put up People's Exhibit 182, please, paragraph 5, and this can go out to everybody, thank you. It is a little hard for me to read it from back here. This is part of the statement of admitted facts that AMI entered into with the Southern District of New York that is appended to the non-prosecution agreement, is that right? That's correct. And did you say, or did AMI say in this document that AMI's principal purpose in entering into the agreement was to suppress the model story so as to prevent it from influencing the election? That is correct. Is that true, Mr. Pecker? Was that your purpose in locking up the Karen McDougal story, to influence the election? Eyes. The provisions about her being on the cover and writing articles that she wasn't even writing, why was that included in the contract? It was included in the contract, basically, as a disguise of what the actual purpose of it was. What was the actual purpose of it? The actual purpose was to acquire lifetime rights to a story so it's not published, wouldn't be published by American media, it would not be published by any other media source. Now, did you ever tell Cameron Stratcher, before he consulted outside counsel, that the true purpose of the contract that he was asking outside counsel to review was influence the election? No. Now, prior to Mr. Stratcher's discussion with outside counsel, did you ever inform Mr. Stratcher that you intended to transfer Karen McDougal's life rights to Michael Cohen? No. Did you ever tell him that Michael Cohen promised to reimburse you for most or all of the money that you had paid to Karen McDougal? No, I never did. Was there a retainer agreement signed by AMI and the outside counsel? And do I need to clarify that a little bit? Yes, please. You testified that prior to the signing of the contract with Karen McDougal, that it was your understanding that AMI's general counsel reached out to election counsel to have them review, the outside counsel, to have them review the Karen McDougal contract? That's correct. Was there a retainer agreement completed in connection with retaining such outside counsel? Yes. Privately, can we please show the witness Bates stamped AMNYDA 74.23 and 4. Do you see that? Yes, I do. What day was the retainer agreement signed between AMI and outside counsel? August 5, 2016. What is the name of the attorney, the outside attorney, who worked on this matter? Chris Murray. Did Mr. Murray bill AMI for the work that he did reviewing the contract between AMI and Karen McDougal? Yes, he did. As you sit here, I think I asked you this on Tuesday, do you know how much time was billed for his reviewing of the contract? Less than an hour. Okay, let me show you privately, and just for the attorneys, Judge, AMNYDA 74.25 through 34. Do you recognize this document? Is this a series of bills from Mr. Murray to AMI for work done in 2016? Yes, it was. QN, I am just going to scroll through all the pages in this exhibit and ask you to keep your eyes out to see if there are any bills for services rendered in the months June, July, August. Yes, there were, so I want to direct your attention to page 8. You see a bill for services rendered on August 3rd of 2016? And does that refresh your recollection does that refresh your recollection as to how many hours AMI was billed in connection with outside counsel's review of the Karen McDougal contract? It was a half an hour. Half an hour. I am showing you what's in evidence as People's Exhibit 156, and this can be shown to everyone. There is the contract that AMI signed with Karen McDougal, is that right? That's correct. And you were asked extensively about this on cross-examination, is that right? Just to remind us, what is the effective date of this contract? August 5th. Does this contract mention anything about Mr. Trump reimbursing you, this contract that was reviewed by outside counsel? No. Does it mention Michael Cohen's name at all? No, it does not. Does the contract mention anything about the plan to reassign Karen McDougal's life rights to either Mr. Trump or Mr. Cohen? No, it does not. Does the contract mention anything about your agreement to help Mr. Trump's campaign that you reached at the August 2015 meeting at Trump Tower? No, it does not. Does it mention anything about your agreement to undertake certain actions at the request of the campaign? No, it does not. Do the contract even mention the word campaign? No. Very recently, Mr. Bove asked you a series of questions about the FEC investigation into the conduct by AMI. Do you remember those questions? And your original position in that case when they asked you a lot of questions, I should say, about your original position after the FEC filed a complaint, is that right? Yes, and your initial response was to deny culpability, is that correct? That's correct. Subsequently, you entered into a conciliation agreement you testified about, correct? And you were shown a page of that conciliation agreement by Mr. Bove as, I believe it was, Defendants AB 131? Mr. Bove, can I have 1 minute to consult with Mr. Steinglass, please? Thank you. On direct examination you testified about a conciliation agreement that AMI entered into, correct? Can we show privately, please, that agreement, specifically page 7? This is the same page that Mr. Bove showed you, yes, on cross-examination, right? That's correct. And he asked you whether your understanding was that AMI had admitted to a campaign finance violation, correct? Correct. And that's what the FEC was investigating, right? Whether or not AMI had engaged in a campaign finance violation. Yes, they were. Notwithstanding the fact that, initially, you and your lawyer denied having done so, you did enter into this conciliation agreement, is that right? And this page that Mr. Bove showed you contains the following language, solely for the purpose of settling this matter and avoiding litigation, with no admission as to the merit of the Commission's legal conclusions. Respondent agrees not to contest that AMI's payment to Karen McDougal to purchase a limited life story right, combined with its decision not to publish the story in consultation with an agent of Donald J. Trump, and for the purpose of influencing the election, constituted a prohibitive corporate in-kind contribution in violation of 52 U.S.C. Section 30118. Does the page that Mr. Bove showed you contain that language? Yes, was it your understanding when AMI entered into this agreement that AMI was acknowledging that the conduct that it had committed in connection with the Karen McDougal payment violated federal election law? Mr. Bove, Judge, I object and ask to be heard at sidebar. Overruled. The court, you want to approach? Mr. Bove, yes, please. Discussion is held at sidebar, on the record. Mr. Bove, Judge, I can clean some of this up on, but Mr. Pecker did not sign this agreement, and recross, it's been repeatedly embedded that this is his agreement. This is AMI's agreement entered into at a time after he left AMI. And the cover page is a cover from the FEC with the agreement, and says that the matter being investigated, as to when Mr. Pecker was dismissed. Mr. Steinglass think I clarified this was agreement that AMI entered into. In any event, Mr. Bove is permitted to clarify anything he wants to. The court think Mr. Steinglass has a right to go back and clear it up. I think you left the jury with a certain impression. Discussion at sidebar concluded, and the following occurred in open court. By Mr. Steinglass, I apologize, Mr. Pecker, I don't remember the question, so I am going to ask the court reporter to read it back. The question, as requested, was read by the court reporter. You testified on direct examination that after you entered into the agreement with Karen McDougal, you formulated a plan to sell the life rights to Mr. Cohen, sell her life rights to Mr. Cohen for a sum of money, correct? That's correct. What was the sum of money that you were selling her life rights for? $125,000. And, in fact, I believe you testified that you only entered into the agreement with Karen McDougal in the first place because Mr. Cohen had promised to reimburse you. Yes, that's correct. So, prior to withdrawing you testified on direct, I can show it to you if you like. There was an agreement, a transfer agreement where you had signed and Michael Cohen had signed, and this was the process of transferring the life rights. Do you remember that document? Yes, I do. And you went so far as to sign the document? I did. After that, but before money actually exchanged hands, did you communicate with your general counsel, Cameron Stratcher, again? I did. And I do not want to ask you about any privileged questions about what you discussed with Cameron Stratcher, but based on that conversation with Cameron Stratcher, what became of your plan to transfer Karen McDougal's life rights to Donald Trump? After that conversation, I called up after Michael Cohen and told him that the deal was off and to rip up the agreement. Can we please show the witness 154, People's 154? And, actually, you can show it to everyone, it's in evidence, I am sorry. Do you remember Mr. Bove asking you a series of questions about this document on cross-examination? Ayes, and he asked you whether this was a standard AMI document? Ayes. And you said that it was, correct? That's correct. It's a fairly standard source agreement intended to kind of lock up a source? That's correct. That's something AMI does a lot? All the time. This agreement was amended by People's 155, can you show People's 155? Alright? Yes, and one of the amendments that People's 155 changed in People's 154 was by extending the exclusivity period from 90 days to in perpetuity? That is correct. Whose idea was it to do that? That was my conversation with Michael Cohen. Is it standard operating procedure for AMI to be consulting with a presidential candidate's fixer about amendments to a source agreement? No. Who withdrawn? Another amendment that was made to the original source agreement with Dino Sajidin was to add a $1 million liquidated damages clause? That's correct. Is a $1 million liquidated damages clause on a $30,000 source agreement standard operating procedure? No. Why did you amend the agreement to add a $1 million liquidated damages clause? That was at Michael Cohen's request. Is it standard operating procedure to have a presidential candidate's campaign person weighing in on what terms of a contract ought to be amended? No. Speaking of Michael Cohen, you testified on both direct examination and again on cross-examination that Michael Cohen told you that he did not work for the campaign, is that correct? Yes. He was paid by the Trump Organization, not by the campaign, is that correct? Ayes. Now, despite the fact that he did not officially work for the campaign, were you aware of the activities that he engaged in on behalf of the campaign? Yes, I was. Who invited you to Mr. Trump's announcement that he was running for president in the first place? Michael Cohen. Did you ever see Michael Cohen go on television to talk about Mr. Trump's campaign talking points? Ayes, that I have. I am sorry? Yes, I did. Did you ever know Michael Cohen to work his press contacts on behalf of the campaign? Ayes. Did you ever receive an invite to a campaign fundraiser that Michael Cohen participated in on behalf of Mr. Trump? Yes, I did. After the Access Hollywood tape was released, who contacted you to ask you to remove the Playboy Mansion story from the Radar online archives? Michael Cohen. And during the meeting during the Trump Tower meeting between yourself, Michael Cohen and Mr. Trump, when you formulated the agreement to help the campaign, was Michael Cohen part of that conversation? Yes, he was. Mr. Bove asked you whether NDAs or non-disclosure agreements were standard operating procedure for AMI. Do you remember being asked that? Ayes. And you testified on cross-examination that during your tenure at AMI there were hundreds of thousands of NDAs, right? Ayes. On how many of those other NDAs had the CEO, meaning the CEO of AMI, coordinated with a presidential candidate for the benefit of the campaign? It's the only one. Were there any other instances where a candidate's fixer insisted on amendments to these NDAs? No. You testified on cross-examination that sometimes you suppressed stories to help a friend? Ayes. And sometimes you suppressed stories to gain leverage against the target of a story? That's correct. I think you talked about Tiger Woods, is that right? Yes, and you wanted him to appear on some magazine covers or do something with AMI. Ayes, and so, you acquired a story and depicted him in a bad light and used it to leverage him into giving you what you wanted? Yes, in this case, did you suppress the stories to help a presidential candidate? Ayes. And you testified on cross-examination that Arnold Schwarzenegger announced his candidacy for governor, and after he announced his candidacy for governor, 30 or 40 women forward with allegations of sexual harassment, is that right? Ayes. And that you told Mr. Bove that you paid hundreds of thousands of dollars to kill those stories? That's correct. I don't want to make you do the math on the spot here, but what was the approximate average of those payments? The largest one was $20,000, then the other ones would be anywhere from $500 to $2,000. Did you spend anything like the $150,000 to suppress any story in connection with the Arnold Schwarzenegger campaign? No. I believe you also testified that Arnold Schwarzenegger was the frontman for some of your fitness line magazines, is that right? That's correct. Why did you spend money, and when I say you, I mean AMI? Why did AMI spend money to silence Mr. Schwarzenegger's